Okay, to go a little bit into the specifics of the case, the Pancos were married in 2009. They got married as an expression of their mutual intention for a religious union, the civil component of which is recognized and supposedly protected by the civil government under the state regulation. And what you're going to find out is that the state of Pennsylvania does not protect marriage. In fact, I don't know of any state that really protects marriage well. There may be a couple of states that do a little bit, but marriage actually has no legal protection. And when marriage has no legal protection, what that means is that the families have no legal protection. This gives the state the ability to go in to redistribute families, to kick a father or a mother out of a child's life, to order child support. This is destructive and it's evil. The law has proven to be totally ineffective in protecting the legal union of the Panko marriage because a divorce decree pursuant to Section 3301D was not predicated on anything Ryan did or did not do as a condition of the rule of law. In fact, this went through the trial court. They found that there was absolutely nothing that he was at fault for. There was no fault alleged against Ryan. The divorce was granted merely because his wife wanted it. Because the wife wanted it, the state backed up that position. He did nothing that was legally wrong, and yet he had legal rights taken from him. For example, his legal right to a family, his legal right to his children, his legal right to his property. This is state-sponsored tyranny, and this is state-sponsored injustice. So what it actually means is this. Taken to its logical conclusion, if unilateral no-fault divorce is permissible, marriage has absolutely no legal protections. And in every state, marriage is a sham institution. It is a lie. The states that say that they have marriage are committing fraud because there is no legal protection for it. You get a marriage license, you get married, you think you have a legal status that should be protected by law. The states do not protect it. It is a sham. It is fraudulent. This is something that is one of the most horrific things that the states could actually do. Now, in this instance here, the master of divorce, and different states have different procedures, but the master of divorce supposedly did not err. He determined that based on the plaintiff's wishes, based on Laura's wishes, that the marriage is irretrievably broken. Basically, again, whenever a petitioner wants a divorce, he or she will automatically get it. And I believe later on he said he basically had to. And he made up something about irretrievably broken. They had differences of opinion. She didn't want to be married. So basically what he is saying is because whatever her wishes are, whatever her wants and desires are, that is what he's going to go with. And what he said is that reconciliation cannot happen without the effort of two willing parties. That may be the case, but nevertheless, there are still legal components to a marriage. And if a person wants to leave, that person should not be rewarded and incentivized for leaving. Many judges actually talk about the issue of unnecessary divorces. Some judges have gone so far as to say at least 40%, sometimes even 50% of the divorces that are granted are unnecessary divorces. They're merely somebody crying out for help, and the state has divorced a family by sheer force of will. They have destroyed a family when that family was easily reconcilable, and the state should have some type of obligation, should bear some liability for the destructiveness of its practices. So again, when you look at the idea of irretrievable breakdown, this begs the question as to why marriage exists at law at all. If there is no legal protection for marriage, why does it even begin? Well, why does it even exist in law? There are absolutely no legal constraints beyond the parties' momentary feelings. You can be married for 25 years and your wife wakes up and says, "Oh, I want a divorce." And there's nothing you can do against it. She may have been perfectly happy for 25 years, but now she wants to find herself or something like that. Or you can say, well, I've been married for 3 months, but now I'm falling out of love. Marriage is more than a feeling. Love is more than a feeling, and that's where we err a lot of times because we somehow equate love with feelings and marriage with love. So marriage is based upon love, which is based upon feelings. So marriage is a feeling. Marriage is a legal status. When you get married, again, you change your legal status from either single or divorced, whatever you were, to married. You are married. It is a legal status. There are benefits and rights that come along with that. And the Commonwealth of Pennsylvania has clearly demonstrated that Section 33.01D has abolished the civil institution of marriage because the law does not establish any marital rights, duties, or obligations capable of protection as it ought. If all marriage is based upon is a feeling, a momentary feeling, the whole thing about marriage is a complete fabrication In Texas, for example, we talk about marriage and the people have a duty to support each other. What does that mean? Well, there should be some type of obligations to each other. But when marriage is based only upon feelings, there are no marital rights, there's no duties, there's no obligations. It's completely nonsensical. So if you look at the trial court proceedings, in Ryan's case, the trial court found no breach in obligations as prescribed by section 3301D. Absolutely none. Some were basically entered into the court probably because the attorney for Laura told her to do so, that there was no real cause of action, no fault. The Superior Court affirmed that trial courts are not entitled to grant divorces based solely upon an individual's viewpoint. So if there were no legal violations, on what basis did the trial court grant this divorce? I think it's my viewpoint, it's my belief, it's my opinion that the marriage is irretrievably broken, and that's enough. So the trial court had a problem right here. And what it comes down to, once again, as mentioned earlier, is that the plaintiff's viewpoint or the petitioner's viewpoint becomes the only thing upon which a divorce is granted. This is actually forbidden by the Establishment Clause of the First Amendment. And what was very interesting in this case is they said to Ryan that we could not deny the divorce based upon your viewpoint that the marriage was not irreconcilable. However, the court actually granted the divorce based on the viewpoint that the wife said it was irreconcilable. So what's happening right now again is that the state is taking a viewpoint. It will always side with the person who wants a divorce. It will always side with the person who says that the marriage is irretrievably broken. It is a state-sponsored viewpoint, which actually is contrary to the Establishment Clause of the First Amendment of the United States Constitution. So the Superior Court was focused on Ryan's viewpoint as a prospective violation of the constitutional law, rather than focusing on the endorsement of Laura's viewpoint that the marriage was irreconcilable as an actual violation of constitutional law. So reasons for granting the petition: because it violates the restrictions on legislative powers defined by the federal and state constitutions conferring subject matter jurisdiction. The legislature did not prescribe a rule of action or create any general liability by which the state is regulating public conduct. The statute targets ideological enemies by sponsoring the viewpoint that the marriage is irretrievably broken. Once again, if there are fault-based reasons for declaring a marriage void, that is what the divorce law is supposed to regulate. And once again, looking at the example of speeding, if I'm driving 75 in a 35 mile an hour zone, I can be ticketed because I'm driving 40 miles over the speed limit. And if it's a school district or something like that, there's a lot of other things that can happen, but it is my action that is punishable. It's not my viewpoint that, well, all speed limits should be null and void. That I can believe that, but so long as I actually obey the speed limit, there is no reason for the state or for a police to arrest me and for me to be fined. It's when my conduct says, okay, I believe this, or maybe I don't believe this. Maybe I believe that the speed limits are good, but my conduct inadvertently violates that and I get pulled over. I didn't even realize I was going 55 and a 35. I just was daydreaming. I am still able to be punished and fined based on my conduct, on my action. I cannot be punished and fined based on my viewpoint, and yet what Pennsylvania is stating is that based upon a viewpoint of irreconcilable differences, they can actually go in and destroy a family. So the statute targets ideological enemies, and they are ideological enemies because the state, without exception, 100% of the time, there are no exceptions, the state will always side with the person who is alleging irreconcilable differences, irretrievable breakdown, whatever it may be, whatever the magic words are in that state. So the law exclusively favors those who want to dissolve their marriage. So Section 3301D does not serve a neutral purpose, and it is directly opposed to all views favoring the enforceability of the institution of monogamous marriage as a civil institution. Marriage has no legal protections. If you're two young people who want to get married and think that you're going to enter into marriage and you're going to have all these protections in marriage, wrong. You don't have them. You might get some of the benefits, but they last only as long as both of you want to stay together. Marriage, by definition, especially from a Christian perspective, is to be a man and a woman for a lifetime. There are specific exceptions, perhaps you can argue, in which divorce may be permissible. But when you get married, it's supposed to be for a lifetime. All of our family codes basically assume that, and it's very easy to prove because the family codes don't say, "Hey, we're going to offer you a 2-year marriage license. We're going to offer you a 1-year marriage license, which with renewable 1-year terms." No, when you get married, the idea is it's for life. And these marital contracts, these marital licenses, whatever you want to call them, I believe that the state is committing fraud because the state should be the enforcer of the contract, should be saying, wait a minute, you got married, you applied for this, and we need to defend the institution of marriage rather than destroy it willy-nilly anytime one person wants to. Under the First Amendment, freedom of belief is absolute. The law may regulate conduct. So, you may be of a certain religion that believes it's okay to smoke peyote or do something else. And, that may be your belief, but if you're doing it illegally, the state does have a right to arrest you and to fine you. Because the state regulates conduct, it does not actually regulate beliefs. If I say I believe in the deity of Christ and the state says if you believe in the deity of Christ, you need to be persecuted and prosecuted and thrown into jail, the state cannot do that. The state is not able to establish and endorse a religious viewpoint or any viewpoint. It can regulate conduct. It cannot regulate your beliefs, personal, whether they be religious or whatever. In the second case of the state constitution, there are laws that actually prohibit granting special laws, granting divorce. And I will say, especially in Texas, I don't know exactly what takes place in Pennsylvania. I don't know this one well enough. But in Article 3, Section 5613 of the Texas State Constitution, the legislature is forbidden from passing special laws granting divorce. So in 6.001 of the Texas Family Code talks about insupportability. That is a special law granting divorce. What it does, it lets the person, the petitioner's will, desire, wish, whatever it may be, that is the operative. It has the force of law. Marriage is more than just between two people. We recognize that marriage has a public good. We recognize that marriage is the best institution for children to be born and raised in. That a child's natural mother and father have the rights, the duties, the obligations to raise a child. And if they're fit parents, the state has no right even to interfere with that. When you talk about unilateral no-fault divorce, what you're also talking about is that the state is saying that we can destroy the parent-child relationship because the state will make one person a primary custodial parent, another person a non-custodial parent. In other words, a visitor, and usually a paying parent. You have to pay child support. The state actually financially rapes people, and they have caused a lot of damage with this. The state has done things that have created tremendous social problems. We know that divorce causes problems in children. Children of divorce are more likely to commit suicide, more likely to drop out of high school, more likely to have alcohol and addiction problems, more likely to get pregnant out of wedlock, more likely to have an abortion, more likely to suffer mental health issues, more likely to divorce themselves, more likely to have physical health symptoms. And this is not just by a marginal factor. This is sometimes by a factor of a lot. Children of divorce are more likely to be rapists. How about that? The state is always against rape, but yet they are creating little rapists by allowing children of divorce to so easily be created. When you look at human trafficking, you know who's more susceptible to human trafficking? Children of divorce. We have our state talking about we're in the fight against human trafficking, we're fight against rape, we're fight against this, fight against that, and yet the very instrument that creates these individuals, the state sponsors. And this is a shame. This is a criminal action, in my opinion, by our state. Oftentimes they invoke the best interest of the child. The best interest of the child is to be raised in an intact family with both mother and father in almost every instance. There are some times that may not be the case. Divorce in those instances is traumatic to the children nevertheless, and there needs to be some type of healing and help for them. But this unnecessary divorce, especially, and I refer to this back to the state of Texas. State of Texas is egregious in this. In Pennsylvania, they used to have a 2-year waiting period. Now they cut it down to 1 year. In the state of Texas, it's 60 days. You can be married for 35 years, and in 60 days, you can get a divorce. and that is completely it's completely wrong. And again, for any reason, for no reason, you can make up a reason. You might have been the best wife, you may have been the best husband, you may have been the best mother, the best father. You can lose access to your children overnight. You can be a 25% parent versus a 100% parent, and the state will punish you further by making you pay child support to the parent who has the kids. And it's really contradictory that you would have no fault divorce, and then when you talk about children, you say, well, now we have to find fault with one of the parents. We have to make a better parent and a worse parent. If it's no fault divorce, it's no fault divorce. The standard should be 50-50 right off the bat, or whatever. But really what it should be is that the state should be saying, you prove to me why divorce is necessary. You have to bring forth a case. We're not going to let you diagnose yourself. You need to show us why divorce is necessary. And if not, you applied for a license from us. We have an obligation. It is a public policy of the state to support marriage if it really is the public policy of the state. Getting back to the case here, then, the court is not capable of making a contrary determination in the absence of a generally prescribed liability. The court, by virtue of adhering to divorce statute, must necessarily endorse one party's viewpoint. And what happens with unilateral no-fault divorce, the state always, again, without exception, endorses the viewpoint of the person who wants a divorce, period.